Trump administration is playing with fire, likely to blow up in their face. I think it's dynamite, because now they've sent in a new submission to Jeb Boseberg, the chief judge of the D.C. District Court, in response to his command that they file a better affidavit, a sworn statement under oath, telling him, with somebody with knowledge at the cabinet level position, whether they are really considering, as a Trump administration, invoking the state secrets privilege, which doesn't apply in this context, to deny Jeb Boseberg the information that he's demanding as to whether they violated his orders to continue to use deportation planes sent to El Salvador filled with Venezuelans after he ordered them not to. Now they're trying to claim, well, we'd like to tell you, Judge, but maybe it's the state secrets privilege. Maybe it isn't. It's a shell game always with the Trump administration. Well, Jeb Boseberg doesn't like shell games. Most federal judges don't. And so he ordered them to file another declaration because the first affidavit sucked. There's no other way to put it, or as he put nicely, was woefully insufficient because it was from somebody who didn't even have knowledge of the deliberations as to whether they were going to invoke the privilege. Classic hearsay. I'm not hearsay. I'm here. I'm Michael Popok. You're on Legal AF. Let's get into it. Got another update here on the Boseberg Chief Justice Roberts Donald Trump saga. Kicked off last Saturday after the judge expanded his temporary restraining order at an oral hearing and ordered that the planes of Venezuelans be returned to American airspace and be grounded. And yet, after issuing that order verbally, which judges are allowed to do, I've been doing this for 35 years, you listen closely and intently when a judge issues an injunction orally. You ask for the transcript, you take copious notes, but you can't look the judge in the eye and say, well, Judge, it wasn't in writing, so I didn't abide by it. And continue, as Tom Homan, our border czar, said on Fox News when he secretly confessed and said, I don't listen to judges. I just listen to the greatest president in my lifetime. I kept sending the planes. Well, we have a word for that in federal court. It's called contempt. And so the judge says, I want to get to the bottom of how that happened. Who, what, why, where, and how. And they said, we can't tell you. Well, why can't you tell me? It's top secret classified. And the judge said, I have top secret classified security clearance. Well, we may invoke state secrets privilege. And the judge said, the privilege from 1953 from the Supreme Court case, you're going to invoke that now? That doesn't apply. Well, we think it may. Well, I don't think it does. But if you're going to invoke it, you better tell me you're going to invoke it soon. So on the deadline that came and went a couple of days ago, which they were late on, they filed an affidavit asking for more time. The affidavit didn't answer the question. It just said, we're considering the state secrets privilege, but we need more time. We can't do it in 24 hours. So they filed late a piece of paper out of order and irregular. A judge called it ex parte, and then said, we're not going to tell you. It's like that game of I'm thinking of a number 7. Nope, that's not it. We're not going to tell you, Judge. And they put up some poor sucker, although I don't feel sorry for him, some deputy field director in Texas of ICE who said, I wasn't in the meetings about whether they were going to exercise or invoke the state secrets privilege, but I heard there were meetings. So we need more time. The judge says, that's not a sufficient declaration. That's woefully insufficient, as I reported yesterday. So they had to fix it. He said, give me another affidavit from somebody who's actually involved directly with precipient knowledge, factual knowledge of being in the room during these debates and these discussions. And then if you can satisfy that, then by Tuesday, I want you to shit or get off the pot, as they say. It's a legal term. Fish or cut bait, I guess is a nicer way of putting it. And tell me whether you're invoking the privilege, which I've already told you doesn't apply. Just for a moment, that applies when generally when a plaintiff brings a case against the federal government or somebody else. In order to prove the case, they've got to disclose a certain batch of information. And the government swoops in, intervenes in the case and says, wait a minute, that information is state secrets. Judge takes a look at it, usually defers to the federal government, except in the Trump administration. You can't ever defer because you can't trust them. But you would normally defer to the commander-in-chief that says, that's state secrets, or the secretary of state. And the judge would say, all right, I got to remove that. You can't use that to prove your case, and the case gets dismissed. Here, this is the Trump administration versus the judge trying to determine whether there's been contempt of court by failure to abide and comply with a temporary restraining order by the judge and willful disobedience. And the judge says, tell me all about it. They say, well, state secrets. Okay. So they finally filed today, Friday, a declaration from Todd Blanche, of all people. Todd Blanche, if you may recall, his claim to fame was he left his law firm or got fired from his law firm and he formed his own. And his number one and only client was Donald Trump for his criminal cases. So he was the criminal defense lawyer on the wrong side of the 34-count felony conviction in New York. But he was successful in delay, and get the Mar-a-Lago and D.C. election interference case to be backburnered long enough that Donald Trump got elected president. And we know what happened after that. And he was on the team that obtained the insurrection immunity decision by the United States Supreme Court, immunizing this president about all of his criminal instincts, and also helped them with the Colorado insurrectionist ballot case at the Supreme Court. So I'm not covering him with any glory, but he was a decent lawyer for that. And his promotion was to be promoted to the number 2 lawyer in the Department of Justice. I don't think he's qualified for that position. That's often known as the enforcer. That's the bad cop or the homicidal cop. That's the chief operating officer for the day-to-day operations of the Department of Justice. And he's filed effectively a 1-paragraph declaration, which I'll put up on the screen and I'll paraphrase it for you because it's simple. I have personal knowledge of cabinet-level positions concerning the possible invocation of the state secrets privilege. Thank you, Todd. Thank you for that. I assume that means that Pam Bondi, his boss, who is cabinet level as the Attorney General, is in discussions with Marco Rubio, the Secretary of State, and Stephen Miller, a non-lawyer who claims to be a lawyer effectively, and the Deputy White House Chief of Staff, and Kristi Noem, Homeland Security, who's not a lawyer, who also came up with the harebrained idea to use the Alien Enemies Act to deport people in an unconstitutional way, in violation of our Constitution and due process rights. Okay, so I think by the skin of their teeth, skin of their nose, this would probably be sufficient, but I don't think the judge is going to love it. And now on Tuesday, they got to file, now that they're saying they're considering it, they got to tell the judge on Tuesday whether they are invoking it or not. If they are, the grounds for it, that's on Tuesday, along with another brief to describe whether they are in contempt or not, and why the judge shouldn't find them to contempt, because he issued an order to show cause for Tuesday about whether whether they have violated and openly, contemptuously violated his orders, defied his orders, yes or no, on the way to a possible contempt finding. While on Friday, they're going to be in court with a hearing about whether the temporary restraining order that the judge entered should be converted into a preliminary injunction or should be vacated and dissolved. While Donald Trump and all of his minions outside the courtroom, because they don't have the balls to do it inside of the courtroom, and the lawyers certainly don't want to lose their bar licenses, are attacking the federal judge mercilessly as a lunatic, as a criminal, as insane, as a leftist, all untrue, and all things that would get a lawyer sanctioned if he tried to do it in his filings or with the federal judge in a courtroom. But, it doesn't stop Donald Trump. Never stopped them before from bashing judges, their family, their wives, their daughters, judges and jurors and grand jurors and prosecutors and attorney generals. So why would it stop him now as the felon in chief? This is right out of his playbook. So do I think this filing fixed the problem that the prior guy had, where he had no knowledge of the deliberations about state secret privilege? Probably. Do I think it's going to stop the judge from finding them ultimately in contempt? I don't think so. And their constant attacks on him, where people at high places like in the United States Supreme Court have had to come to his aid, is not helping Donald Trump either. I think he's losing votes at the Supreme Court for his most unconstitutional policies and acts. I think he's just pissing off Chief Justice Roberts. And I think Brett Kavanaugh, who is the roommate for Jeb Boseberg, is none too pleased either. I'll continue to follow it all right here on Legal AF. Take a moment, hit the subscribe button. We're already rolling to 510,000 this weekend. And I got great news. In the new rankings and ratings for podcasts, right up there with the Midas Touch Network and Midas Touch Brothers podcast coming in number 1, we're in the top 10. We bounce between 8 and 12. And that's in the world, and that's on all genre. That's because of you. So we're so indebted to you as we continue to grow this pro-democracy channel in collaboration with the Midas Touch Network. So until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.